Okay, so let's talk about the Truth in Lending Act. Um, so, as the name indicates, really the objective, the thrust of this legislation is transparency. All right. Um, it didn't really preclude any type of loan instruments or products or devices, but it did make it harder to sell them because it was transparent to the consumer that this is not the best credit product for me. And also, it facilitated comparison among credit products. In other words, if I have two loans, I can compare based on Truth in Lending Act disclosures to determine which is more economically beneficial to me. So that's really the goal of the Truth in Lending Act. All right. Basically, all of the terms, including the annual percentage rate, i.e., your interest rate, finance charge, so any additional charges, charges to establish a loan, prepayment penalties, uh, late fees, all of those things have to be disclosed. Amount financed, and I need to change that, um, and total payments, including interest and principal. All right, all of that needs to be disclosed to you as a borrower. All right. Um, Equal Credit Opportunity Act really just precludes discrimination in granting credit on the basis of race, religion, or other federally protected class. So race, religion, national origin, color. Um, the requirement of a cosigner. So this is somewhat technical, but if a borrower meets the standard required for credit by the lender, i.e., meets the standard required that the lender traditionally lends, the lender cannot ask for a cosigner. And in fact, if they do, it's illegal. In fact, in the case that is in the text, the lender had a cosigner, but met the credit terms needed for credit from that particular company without the cosigner. And so um, the cosigner was basically treated as um, not a cosigner because they met the credit terms necessary for credit. All right, so that's the way that works. You can't selectively require cosigners for certain groups because in practice, what it amounts to is that tends to adversely affect um, certain minority groups, certain gender groups uh, in a disproportionate manner, right? Okay. If you own a credit card, you've been told that your liability is limited to $50 under federal law. Most card issuers, the major card issuers, do better than that and limit your liability to $0 for unauthorized transaction on your card. But the federal law is 50. Lenders can change it to 0, and most do. All right. Other minor credit card rules here that we won't necessarily get into. Um, and the Fair Credit Reporting Act. So this governs how the credit bureaus, and there are three, um, manage, report, give access to the information on your credit report. All right. And basically, it requires that that when information is released from your credit report, um, it be done for a specified purpose, i.e., establishment of credit, um, or granting insurance or something along those lines. If you are denied credit, um, the creditor has to give you the source of the information that the decision was based on. Right? So if you apply for a credit card and don't get it, and it was based on information in your Experian credit report, the creditor has to tell you that, and oftentimes give you access to that report so you can get a feel for what's in it. All right. The exact same disclosures are required when you are in fact given a product, i.e., a credit card or insurance, and you're given a higher rate based on credit worthiness. All right. Now, credit reporting agencies, and there are three, and they basically form somewhat of a monopoly that we'll get to. Well, it's not a monopoly, it is a monopoly because there are three. Um, we'll get to that in chapter 26. But the reality is that in traditionally they haven't been very receptive to the needs of consumers whose credit reports have bad information or incorrect information. Um, they can be subject to damages if they don't live up to the rules in the Fair Credit Reporting Act. And so damages is actual damages. So if I lose a job due to a credit check, some employers do credit checks, um, and there's bad information, actual damages could be lost wages, um, plus additional damages. And when we see that, we'll see additional damages at a few other places. What we're really talking about is punitive damages, damages that are meant to punish the credit bureau up to $1,000 plus attorney fees. So, in other words, if um, an employer checks credit for a job and there's bad information, I don't get the job, and it takes me several more months to find this suitable or similar job, and I'm able to demonstrate, say, $20,000 in actual damages, um, plus additional damages of up to 1,000, which doesn't sound like a lot based on the scale and scope of the credit reporting bureaus, but um, and so, but say I'm entitled to that as well, and then my attorney fees, say they're $5,000, I could get all of that as a result of the um, bad information. Well, not necessarily bad information. I'd have to demonstrate that I asked them to change it and they didn't comply with what they're legally required to do. So the mere fact they have bad information isn't enough for liability. I have to notify them and they have to go through their process. And if they fail to do so, they're liable for those damages. Okay, Fair Debt Collection Practices Act. So this applies only to debt collectors, right? Not the original party you transacted with. So your debt has been sold, often for pennies on the dollar, and now their practices are governed by the Fair Debt Collection Practices Act. All right. And so the rules: can't contact the debtor at work, but the debtor must say, "Don't call me, I'm at work." All right. Has to let the creditor know that you please don't call me while I'm at work. I'm trying to work here so I can earn some money to pay you. Um, Can't call the debtor at inconvenient times. So the 4 in the morning, that's harassment, right? Um, can't contact third parties, and this was shown to be kind of harassing. You can't call somebody's neighbor because that's primarily for embarrassment, not necessarily to collect a debt, but you know, to embarrass somebody. You can't call somebody's neighbor and tell them that they don't pay their bills. That would not be uh, a good thing, and it is illegal, but it has happened. A debt collector cannot lie to you or harass you. So making false statements is illegal. So, um, for instance, um, if if the debt collector claims to plan to sue you on a debt that they can't legally sue on, for instance, the statute of limitations has run, that's illegal. It's a fine line because they can attempt to collect debts that the statute of limitations has run on, but they can't say, we will sue you for this debt, because that would be a false statement. You can't legally do that. And you can tell the debt collector, do not contact me. Refusing to pay. Um, and once you do that, then they cannot contact you. Other than to say, well, since you don't want to contact us or work with us, we plan to sue you. They can do that. But once they've done that, all communication must cease. All right. And the damages look very similar. Actual damages plus additional damages of up to $1,000 and attorney's fees.